Chair.
Good morning.
Morning, Chair.
Morning, ma'am. And good morning to all those who are watching us from home. Today we will be dealing with two issues, the Land Court Bill and the progress report in terms of the project plan on how we are going to be processing the hate crime, hate speech bill. I'm sure that this is not going to be a long meeting. So we will be out of this meeting, I think, before 12. And as I said, members, that it's very difficult to compile a long-term program. So we will be compiling weekly programs. Our program has significantly changed since we have to chop and change to accommodate some of the new issues that are coming up, including the issue of the traditional court bill. And we had to also accommodate this this issue of hate crime, hate speech, which was raised last week. So members would be informed each week as to how the program would look like. I suggest that maybe we'd start with Mr. Dupree, who will just take us through the progress that he's making, in fact, the project plan, because we are not expecting him to report on the details or the content of the hate crime, hate speech bill. We just want to know the time frame so that we can be able to rework the program to accommodate the finalization or the processing of the hate crime, hate speech bill. Over to you, Mr. Dupree.
Good morning, Mr. Chair. Good morning to the members of the committee and my Deputy Minister and colleagues on the platform. Mr. Chair, before I proceed, I see there is I think there was a raised hand. With regard to the with regard to the outstanding comments on the hate speech bill, we have decided not to, if I may put it, clutter the existing summary with additional summaries. So we have prepared, or we are in the process of preparing, a supplementary summary. So the committee will then have, at the end of the day, two summaries on the hate speech bill. The supplementary summary, of course, will then provide the additional information. And we undertake from the department side, Mr. Chair, to have that available next week, a finalized supplementary summary on latest Monday, Tuesday. I don't know whether that will assist the committee. We appreciate that the committee's time is very valuable. I am I think, if I could venture a guess at this stage, I am halfway through the additional information that has been provided to us. What the committee secretary did was to send me 2 folders of the sum total of the comments that were received by the committee, and it unfortunately takes a bit of time because some of them are substantive, in excess of 40 pages per summary or per submission. So unfortunately, it does take time. That is what I can indicate to the committee at this stage, Chair.
Thank you very much, Mr. Dupree. Thank you for the update. Members, are there any questions? And I'm sorry, members, I'm using the iPad to have load shedding here, and sometimes it looks a little bit untidy when I keep on pressing the camera on and off. But at about 10:10, I think I'll be back on my laptop, which will be much better. Are there any comments, members? Let me check. Honorable Horn, and welcome to our Deputy Minister, Honorable John Jeffrey. Thank you very much for being with us today, Honorable Deputy Minister. And I'm sorry that I had not opened for apologies. Are there any apologies?
Chair.
Yes, Honorable Horn.
Thank you. My apologies also for being late. Just when one thinks you know Zoom, you apparently don't. I was in a waiting room which said the PC deliberations on the land court bill, but then seemingly I was not in the waiting room of this meeting. So that's very strange, but be that as it may, maybe if it's not on record at our secretariat, just confirm that the Honorable Breitenbach has tendered an apology for the duration of this week. She is on a overseas study tour and won't be able to join.
Okay, thank you very much. Any other apology?
Good morning, Chair. There's an apology from Ms. Yako.
From who?
Chair, from Honorable Yako.
Oh, okay. Okay, thank you very much. Those are the apologies that will be recorded as such. Honorable Honorable Deputy Minister John Jeffrey.
Chair, thanks. No, just I following on from Mr. Dupree's input. I think we can undertake to have the submission, the additional summary or the summaries of the submissions that were missed by Monday morning. So we could look at continuing with the bill from Tuesday of next week.
Thank you very much, Deputy Minister. Honorable Swart.
Thank you, Chair. Just also to give my apology, I might need to leave early today. I'm just trying to understand what Mr. Dupree says, and I just want to express my gratitude also to the department and the committee members who worked very hard, our secretariat, to arrange this at the weekend for the past few days. So we're going to have two documents then dealing with the public submissions. The one, the initial summary, and there's going to be a second one which we're going to have to read together with the first document. So that could be a bit tricky, but we do appreciate the time constraints and the pressure on us to deal with this legislation. So thank you, Chair, from my side.
Thank you very much, Honorable Swart. Any other member? No. Thank you very much, Mr. Dupree, for the hard work. We know that it's not easy. And at the same time, I think it's important that as you work hard, you must also look after your health. So we really do appreciate that you had to, in fact, you worked throughout the weekend to make sure that next week we do have the document. But if anything happens and it is not possible, please inform us at least by Sunday so that we are able to plan accordingly. So things as they stand now, we are going to reserve next week for hate crime, hate speech, where we will first, I think on Tuesday, we will deal with the responses, the outstanding responses, and then we will take it from there. Thank you very much, Mr. Dupree, and to your team, and thank you to the Deputy Minister for his leadership. Are we done with this issue, members? Mr.
Chair,
Dupree?
if we're done, can I also be excused? I just come for this item, not for the land court, which the officials are more than capable of managing.
Thank you very much, Deputy Minister, for your attendance. You are excused.
Thank you.
Mr. Dupree?
Thank you, Chair. Mr. Chair, with regard to the concern raised by Mr. Swart, I would like some guidance from the committee. I thought it would have been better just to prepare a supplementary summary. If I have to insert the additional comments in the existing summary, I will have to highlight it to the committee so that it can easily be identified. But I will be guided by the chairperson whether the chair would think it's better to rather have the one single summary, or then the original summary with the supplementary summary. And I would like maybe just to mention, Mr. Chair, and request your permission. I have requested Mr. Makudubete to share the working document with the committee and to take the committee through the additional proposed amendments, of which we would like to also maybe, and I'm not speaking on behalf of Mr. Makudubete, but I think we need to, from the department side, highlight to the committee the proposed amendments in the schedule to the bill. Thank you, Chair.
No, Mr. Dupree, I think your problem, we are dealing with two issues in one. So a person has to listen to you up to the end. You are dealing with the hate crime, hate speech process, and you're combining that process with the land court bill. I think with respect to your second one, which is your last one, I think the expectations generally was that Mr. Makudubete is dealing with the issue as we are concentrating on the summaries of the hate crime, hate speech bill. So I think your request is perfectly in order that Mr. Makudubete will flight and lead the discussions on the changes that have been made. With respect to your first one, your first request, I'll be guided by members because I think it's a matter of style and preference. I would be happier with your approach of a supplementary document because the highlighting, I think it makes it to be quite untidy. But I think other members might have a different view. I think it's just an issue of a personal style and what would be easier for members. I would generally be guided by them. Honorable Nivo Tuchen.
Thank you very much, Chair, and good morning. Apologies, I'm using two different devices, so it's also a bit of a confusion there. I do agree. With you, Honourable Chair. Sorry, good morning to everybody on the platform. I do agree with you, Honourable Chair, to keep the two summaries separate so that we can see, with the supplementary summary, we can see that it's from what we missed. So I agree, if it's combined and into one document and becomes highlighted, it will look rather untidy. So I agree with Mr. Dupre's proposal. Thank you, Chair.
Thank you very much. Honorable Swart, are you covered?
Yes, thank you, Chair.
Thank you very much. I think let's agree with the approaches proposed by Mr. Dupre that
Apologies, Chair. Apologies. If the Secretariat can unpin Wilma, Honorable Wilma, sorry, so she can participate.
Okay. Thank you very much. Yes, we honor Mr. Dupre, so you would proceed with a supplementary document on Tuesday. Once we are done, I think we will try and link them to be one so that we are able to move from one view to the other, especially if they are contrary views. So it's going to be quite a bit of a process, but I think once we are done with the responses, then we will move to clause by clause processing of the bill. We still think that because of the delays that have happened and with the fact that we would be adjourning end of this month, that the bill might be towards the end, but I think we will have to finalize it when we come back. But we will see as we push next week as to how far does it take us. But definitely we will have to finalize the land court bill this term and finalize drug trafficking this term. And then we will see this one, how much do we push. But if there is a possibility that we can finalize it, then that would be good. But if not, we will not rush it. Thank you very much. Let's move to land court bill.
Thank you, Chair. I'm going to ask Mr. Makudubete to take over from me at this stage. I'll second chair the rest of the meeting then with him. Thank you, Chair.
Thank you very much.
Good morning, Chair, and good morning to honorable members, as well as everyone on the platform. I'm thankful for the opportunity to take the committee to this document as amended in light of the discussions that took place during the course of last week, that is on Tuesday. Chair, if I may get an indication, I should have the document on the screen, if I can get confirmation that it can be seen.
Yes, we can see it.
Yes, thank you very much, Chair. As you will see, Chair, it's a continuation of the working document that we have previously used, and we have inserted the new amendments as per the direction of the committee. Just by way of a recap, Chair, during the course of last week on Tuesday, that is, the committee dealt with the issue of the bill having taken away the jurisdiction of the magistrate court, and the committee directed the department to attend to the reinstatement, if I may so say, of the jurisdiction of the magistrate court, so that this court can have concurrent jurisdiction with the land court in relation to land-related matters. So, Chair, I do agree with yourself when you say when the highlights are used in the documents, they become at some stage untidy. This is the classic example, Chair. We have now different colors, but it should not be a big thing because now what I'm going to be focusing on will be the highlights in pink. This will relate to the new amendments as a result of the direction by the committee. The blue and yellow highlights are the issues that have already been dealt with, and that the committee has been taking through those amendments, and we'll focus on the highlights in pink. Now, on the long title, Chair, the portion highlighted in pink, we have attempted to effect the directions of the committee by deleting the exclusive jurisdiction of the land court and provide for the concurrent jurisdiction of the land court with the magistrates court and for certain land related matters. As a result, Chair, the provision of this long title as inserted will read to provide for the concurrent jurisdiction of the land court and magistrates court for certain land related matters. I will continue, Chair. I will not want to skip the document to rush to the highlighted pages. I will just scroll down so that the committee can see, even by way of a recap, what we have done in terms of the amendment, and then I will stop where the highlights in pink appear, which will reflect the new insertion from last week, Tuesday's discussion and the direction by the committee. And the next highlight will be on page 10, where we are essentially inserting the definition of the magistrates court. This follows from the insertion of the reinstatement of the jurisdiction of the magistrate court so that they are able to deal with certain land related matters. So it is necessary that we insert this definition, and to mean any court established in terms of Section 2 of the Magistrates Court Act 1944, that is Act number 32 of 1944. I will continue further, Chair, and I'm in the hands of the committee if the Chair will want me to stop for clarity on any aspects that need to be clarified. The next highlights are contained in clause 7, which is the clause dealing with the jurisdiction of the court. In the same vein, Chair, we are introducing the concurrent jurisdiction of the magistrates court. The revised clause 7.1 will read as follows: subject to the Constitution and except where this act provides, the court and the magistrate courts within whose area of jurisdiction the land forming the subject matter before that court is situated have concurrent jurisdiction in respect of all matters that in terms of this act or in terms of any other law are to be determined by the court. Chair, the document that was circulated to the committee did not delete this term elsewhere. I do apologize, Chair. Our intention is to ensure that it is deleted because of our insertion of the concurrent jurisdiction of the magistrate court. So the document that is in the position of the committee, of the members of the committee, will not have double struck through the word elsewhere. So I do apologize for that. So we are essentially deleting the word elsewhere. The next portion, Chair, that deals with the highlights I do apologize, Chair, so that I do not rush, and in case I skip any portion that is highlighted in pink. Chair, on this page is just a technical change. This paragraph C deals with the default judgment, and it reads: the manner and circumstances under which a judgment by default contemplated in section 18 of this act can be given. We are just deleting the word made and then substitute it with given, because the court does not make judgment. Instead, it gives judgments. Hence, we are substituting that word made with given. It's just a technical correction that we will like to put to draw to the attention of the members of the committee. These are the highlights that have already been presented to the committee. And the next one is also in clause paragraph 3. I'll just scroll up to see under clause 25, dealing with conferences. Subclause 3 is also a technical change that we are bringing to the attention of the committee, so that this clause reads: the order so made by the court is binding on the parties unless altered at the trial to prevent manifest injustice. It's just a cleaning up, if I may so say, and to make the provision read much better. The next change that we have effected, Chair, relates to clause 29 of the bill dealing with mediation. And the change that we have effecting relates to subclause 4, and that we are effecting a technical change, as we have already done in relation to other provisions, to delete the word prescribed, so that this issue can be dealt with and provided for in the rules. So it's also one of the technical changes that we are effecting for the attention of the committee. And also here, Chair, just minor changes by way of deleting and inserting the commas. It's a minor technical change there, as well as in this page, we are inserting a full stop there. Chair, most of these have been dealt with. I'm going to scroll quickly to go to the next highlight, which will appear on, I think, page 66. And this is where we deal with the schedule to the bill. The committee has already been taken through the schedule, and we have inserted the changes to give effect to the direction of the committee in terms of the reinstatement of the Magistrates Court. So under the upgrading of Land Tenure Rights Act, and particularly in relation to the definition of the court, we are inserting this provision so that the definition of the court can mean the land court established by Section 3 of the Land Court Act 2022, or a magistrate court in whose area of jurisdiction the land in question is situated. The next highlights, Chair, relate to the deletion of this paragraph 2 or item 2 of this schedule under item 1 relating to the upgrading of the Land Tenure Rights Act. This deletion is essentially to make sure that we are reinstating the magistrate court. Initially, we were deleting the magistrate court and then replacing that with the court, meaning the land court. Now, because we are reinstating the magistrate court, we are deleting, therefore, the entire paragraph, which was giving effect to the deletion of the magistrate court and giving effect to the land court as the court that was going to deal with that matter. So we are deleting the entire paragraph so that the magistrate court can be reinstated to deal with land matters. The same case is in relation to this paragraph 4, Chair. We are deleting because initially our intention was to get rid of the magistrate court and then give the land court the exclusive jurisdiction. Now, with this insertion or with this deletion, we are essentially reinstating the jurisdiction of the magistrate court. Chair, this one, it's not highlighted, but I think I will need to draw to the attention of the committee because now it will mean that we are deleting the magistrate court here. But however, remember, we are defining the court as the land court and the magistrate court. So the magistrate will be covered by this term court because it includes both the magistrate and the land court. Chair, I'm going to have to pause a little on this on this act. I am alerted by my colleague, Mr. Dupree, that even though the committee was taken through the schedule, the insertions or the changes that we have effected relating to the Land Reform Labor Tenants Act have not been brief or have not been addressed to the committee. So I would like to take this opportunity to brief the committee on the changes that we have effected, which have not been addressed to the committee. And these changes are brought by the deletion in the bill of the provision relating to arbitration. Now, what we have done, Chair, initially the bill was making provision for arbitration in terms of which the judge president of the court was given the discretion whether to refer the matter to mediation or arbitration or to the court for adjudication. However, because we have deleted the provision relating to arbitration in the land court bill itself, we had to effect the changes to these clauses under paragraph 6 of the schedule. We are substituting section 18 of the Labor Tenant Act, in terms of which sections, subsections 7, 8, and 9 are substituted with the following provisions. Here, we are inserting the provision that will see to the referral of the application for arbitration or to the court for adjudication. Initially, the application or the Director General was empowered by this provision, Chair, to refer the application under this act to the court and inform the parties that the Director General has done so. But now what we are doing, because arbitration was initially dealt with in the land court, we have to provide for arbitration in this clause or in this section of the Act or of the Labor Tenants Act, so as to empower the Director General of the Department of Agriculture to refer the application for arbitration or to the court for adjudication. The next substitution is in relation to this subsection 8 of the Labor Tenants Act, in terms of which we are deleting the word court, because the court is no longer going to be dealing with the arbitration, and now the arbitration is going to be dealt with by the Director General, and in replacement of the word court. So wherever the court was put in the center of dealing with arbitrations, we are substituting that with the Director General, so that the Director General can see through and then deal with the process of the arbitration, because it is now out of the terrain of the Land Court Bill. Similarly, Chair, in relation to subsection 9, we are deleting the President of the Court as initially provided for in that subsection of the Labor Tenancy Act, and we are substituting that with the Director General, and that will be the Director General of the Department of Agriculture, Land Reform and Rural Development. Going forward, Chair, relating to subsection 19, we were initially inserting this provision that we are now deleting, because it was intended to substitute the entire section 19 of the Labor Tenant Act. So now we are reinstating the initial provision as it was in the Labor Tenant Act, and then we are making certain changes there as highlighted here, Chair. This is a technical change because now we are talking about the Judge President of the Land Court instead of the President as it was initially included in the Labor Tenants Act. So it is the Judge President that will be referred to here. Now, the Director General, Chair, is the one who is now given the power to refer the application that is contemplated in that Labor Tenant Act to arbitration. And whenever that application is brought to the court or referred to the court by the Director General, the Judge President of the court, when that matter is referred to the court, will be given the power to give such directions as he or he considers appropriate as to the procedure to be followed for the application to be heard by the court. Chair, I hear an echo. I'm not sure if someone is trying to speak, or I'm hearing an echo. Is there someone who's maybe trying to say something perhaps?
I don't think so.
Okay, thank you, Chair. Going forward, Chair, in the same vein, we are deleting the President of the Court and substituting that with the Director General as the official who may appoint an arbitrator in relation to the disputes that are arbitrable that are emanating from the provision of the Labor Tenancy Act. Chair, with regards to paragraph 8, initially we were deleting the entire section 20 of that act. However, because that act is going to this section deals with the process of arbitration. Now, we were deleting the entire section because it deals with arbitration. And now, because now the arbitration processes are taken out of the Land Court Bill, we are reinstating that section, except the deletion of subsections 1 and 2 of section 20 of that act, because these sections are dealing with the judge president, requiring the judge president to do certain things in relation to the arbitration that will have emanated from the dispute out of or emanating from the Labor Tenant Act. Following from that, Chair, clause 9, we are effecting a change so as to remove this part of the subsection, that is subsection 3, so that we delete any reference to the rules. Because the rules, Chair, will be included in the rules of the rules that will be made by the rules board under the Land Court Bill itself. With regards to clause 10, we are substituting section 20, subsection 6, in the same vein by the deletion of the court and replacing that with the Director General. Under section 21, subsection 1, we are substituting the entire section. Chair, this section was still there, but because it becomes untidy when we do piecemeal amendments, we decided to substitute the entire section or subsection with the subsection that will read: the Director General shall submit the determination of an arbitrator referred to in section 26 to the court, and the court may make the determination an order of court with or without such technical variations as may be appropriate. Chair, here we just making a technical change by insertion of the word or. The same case here, Chair. And there will be a change in the numbering of the paragraphs that will flow from the changes that we have effected above. With regards to section 33, we are effecting changes to initially subsection 3, but we are now effecting changes to subsection 4 as well. Now, the change that we are effecting will be here under subsection 3, so as to replace the president of the court or a judge of the court nominated by him or her, and then we are replacing that with the Director General, who may determine that the proceedings for eviction of any person shall take place before an arbitrator appointed in terms of section 19.3. Regarding the amendment to subsection 4, in the same vein, we are deleting the judge president of the court and substituting that with the Director General. Here we are deleting this provision that initially was intended to delete the subsection 4 of section 33. So because of the reinstatement of arbitration, we are no longer proceeding to delete subsection 4 of section 33. Chair, that is all in relation to the Labor Tenancy or Labor Tenant Act. and the changes that we have effected as a result of the changes relating to the deletion of the arbitration proceedings out of the Land Court Bill. Chair, the next act is the Communal Property Association Act. We are reinstating the jurisdiction of the Magistrate Court so that the definition of the court can mean the land court established by Section 3 of the Land Court Act 2022, or a magistrate court in whose area of jurisdiction the land in question is situated. Chair, this definition was amended as a result of a provision under subsection 13 of that act, because it was giving a concurrent jurisdiction to the magistrate court. And because we are reinstating the magistrate court, we are no longer proceeding with this deletion. Instead, we are reinstating the magistrate court, of course, with the magistrate court cited in capital letters for M and C. Chair, the next change that we need to bring to the attention of the committee relates to the ESTA, where in the same vein, we are reinstating the jurisdiction of the magistrate court, in terms of which, because here the definition of the court was concurrent, where any competent court was having a jurisdiction in terms of this act. Now, we are restricting this definition of the court to mean the land court established by Section 3 of the Land Court Act 2022, or a magistrate court in whose area of jurisdiction the land in question is situated. Chair, I'm closer to finalizing the insertion that we have effected following last week's discussions on Tuesday. Chair, with regards to the PI Act, so-called PI Act, in the same vein, we are deleting, or we are amending the definition of court to mean the land court established by Section 3 of the Land Court Act 2022, or the magistrate court, now with a capital M and C, in whose area of jurisdiction the land in question is situated. This, Chair, is to essentially give effect to the direction of the committee in terms of which the jurisdiction of the magistrate court has to be reinstated in relation to matters emanating from or out of the PI Act. So, Chair, this is to essentially use the capital C for court wherever it appears under that PI Act. And this is the last highlight in relation to this document. And I will hand over back to my colleague, Mr. Dupree, if maybe there is any aspect that needs to be highlighted to the committee. But with all this, it brings me to the conclusion of my briefing on this, on these changes that we have effected. Thank you, Chair.
Thank you very much, Mr. Mokolobete. Mr. Dupree.
Thank you, Chair. I do not have anything to add at this stage. Thank you, Chair.
Thank you very much for the hard work. To the team, Mr. Dupree, Mr. Mokolobete, and other members of the team whom we might not know. Thank you very much. Members, that is the presentation on the Land Court Bill. Honorable Horn.
Yes, thank you, Chair, and let me join you in thanking the drafting unit. It's quite clear that they, in a meticulous way, then went about restoring those powers to the Magistrates Court in the current version. May I, on this issue, just raise one or two matters, Chair? The way I read Section 7 as it now stands, it in very clear terms says that there's this concurrent jurisdiction unless otherwise indicated by the Act. Now, my understanding is that by way of the decision of the committee and as is being given effect to by this draft, that would then mean that all the only matters in which this court for now will then have exclusive jurisdiction would then be restitution matters in terms of the Restitution and Land Rights Act. I don't know whether my powers of concentration is not what it's supposed to be this morning, but I can't seem to find where that specific aspect is then addressed in the current version of the bill. That's the one question I wanted to ask, Chair. The second question I wanted to ask is,
Honorable Horn.
Yes.
Honorable Horn. Yes, maybe let's deal with that question first.
Okay, thank you, Chair.
Yes, and then we'll come back to the second question we'd want to raise, or second point we'd want to raise. Mr. Makulubet and Mr. Dupree.
Thank you, Mr. Chair, and thank you for the question. I will scroll down to the schedule. In terms of clause 7 as amended, we are now deleting the word exclusive, and we are replacing that with concurrent jurisdiction. However, when we go to the schedule, the various pieces of legislation are the ones who are going to give the exclusive jurisdiction in certain instances, or the concurrent jurisdiction of the Land Court and the Magistrate Court in certain instances. For instance, in the upgrading of Land Tenure Rights Act, we will have the concurrent jurisdiction. I will try to scroll down to another piece of legislation, the Land Reform Provision of Land Assistance Act. This act, you will see from the insertion of this new clause 12A, it will be, this schedule is given this act, is given the Land Court exclusive jurisdiction, because we are saying the Land Court established in terms of Section 3 of the Land Court Act 2022 has jurisdiction to resolve any dispute arising from the application of this act. So in terms of this provision, the Land Court exclusively is given the jurisdiction to deal with matters emanating from that act. The same is the case with other pieces of legislation. For instance, the KwaZulu-Natal Ingonyama Trust Act. That act talks to the Land Court as being given the jurisdiction to resolve dispute emanating from this act. So is the case with various others. Those that will have concurrent jurisdiction will be specified. So, like I've highlighted, especially with the ESTA Act and also the PI Act, those will have concurrent jurisdiction. However, certain pieces of legislation will have the exclusive jurisdiction of the Land Court. However, in clause 7 itself, then the exclusive jurisdiction will have to be deleted, because what we will have in the schedule It's no longer exclusive jurisdiction. It will be concurrent jurisdiction and exclusive jurisdiction in certain instances. I hope this clarifies the position. Thank you, Chair.
Thank you very much. Honorable Horn, are you clarified?
I am. Thank you, Chair.
Thank you very much. But I think for us members, even if we were to be asked or interviewed, I think, but not for the purposes of drafting, just for the purposes of communication, it would be good whether it is the Parliament Legal Services or yourselves, that we have sort of a pager that would be able to say, these are the exclusive jurisdiction and these are the concurrent jurisdiction. But now it is all over. I mean, it's good for the purposes of technical legal drafting, but for the purposes of communicating, especially if we go to our local radio stations, members who might, some of them who might not even be members of this portfolio committee, would be asked questions, especially for areas of exclusive jurisdiction and the concurrent jurisdiction. So if there can be some what talking points or talking notes on how this is going to work. I'm not sure whether would that be done by the Parliament Legal Services or by yourselves. Mr. Makudubete.
Thank you, Chair. I was struggling to find the mute button. Chair, I believe we will be in a position to prepare a document that will deal with that a specific issue, and in terms of which maybe then we by way of a table rather than a schedule that we have here, a table that will set out various pieces of legislation and then the specific provision that gives the exclusive jurisdiction of the land court and those that are giving concurrent jurisdiction of the land court. Chair, I believe we are in a position to do that, and we may even liaise with the parliamentary legal services for assistance and the manner that it can be done for the purpose of the committee and the members at large. I believe, Chair, we will be in a position to do that. Thank you.
No, thank you very much. Can we now go back to Ms. Honorable Horn? Your next question.
Yes, thank you, Chair. My next question is about, I want to say, the knock-on effect of all of this on appeals. So ordinarily, the magistrate's court or any judgment or order from the magistrate court is appealable to the High Court. Now the Land Court has the status of an High Court, but we have determined that there is concurrent jurisdiction. So I don't know whether the department has reflected on what the impact is thereof, whether then it would mean that while there is concurrent jurisdiction, a litigant may still choose to appeal to the Land Court, being a specific or let's say of course a specialized High Court in respect of matters where the Magistrates Court has issued an order in respect of concurrent jurisdiction, and whether the advice would be that it is something that must be regulated through this bill. And if it is then an appeal to the Land Court, whether it is then to a full bench or a single bench. Thank you, Chair.
Thank you very much, Mr. Mukulubete.
Thank you very much, Chair, and thank you to Honorable Hon for the question. I seem to be struggling all the time when I want to, to press the unmute button. Chair, the schedule gives the Land Court and the Magistrate Court concurrent jurisdiction. Only these pieces of legislation that are included in the schedule will have the jurisdiction of the Land Court exclusively in one instance, and concurrent jurisdiction of the Land Court and the Magistrate Court in certain instances. Now, for purposes of the appeal, matters that are appealable where the Magistrate Court has jurisdiction in terms of these pieces of legislation are going to go directly to the Land Court. Only these that are listed here. Those that are not listed will have their jurisdiction or the appeal directed to the High Court. Because, Chair, you remember, if you think back as to what we were trying to do with this list, our intention was to confine all these pieces of legislation to the exclusive jurisdiction of the court. We have, through the engagement with the various departments, isolated which specific pieces of legislation are going to be immediately placed under the exclusive jurisdiction of the court. Now, all of these will have exclusive jurisdiction of the Land Court, and instances where the Magistrate Court has dealt with the matter will be appealable to the Land Court. Thank you. That will be my response to this. I'm not sure if my colleague, Mr. Dupré, is able to maybe shed some more light on this. Thank you, Chair.
Thank you very much, Mr. Dupré.
Chair, nothing to add at this stage, but it is something that we'll certainly have a look again and go through those pieces of legislation just to make sure that if there are any appeal provisions that they fall in line with the bill itself. Chair, and maybe at this stage, after the questions by the committee members, I would maybe just like to highlight one aspect to you. I think it's something that fell through the cracks from the previous meeting, but I am duty bound to point that out to you, but I'll allow your members to raise the questions. Thank you, Chair.
Honorable Hon, are you clarified?
Yes, Chair, not necessarily, but I have taken away from the input from the department that they will again look at this matter. My view would be that given the fact that we are creating a creature of statute here, that it will have to be stated very specifically in the bill, if in matters where the magistrates court deal with the matter in a concurrent way, the appeal lies to the Land Court and not to another High Court. But I mean, that's just, I want to say my sense about it, but I would appreciate their considered further feedback in this regard. Thank you.
Thank you. Mr. Mukulubete.
Yes, thank you, Chair. The suggestion is noted from Honorable Horn, and we will indeed, as my colleague Mr. Dupré has indicated, that we will look into the entire bill and then see how or where we can slot in the specific provision that will clarify that issue beyond doubt as to the appealability of magistrate court matters directly to the High Court in relation to the matters that are listed in the schedule to the bill. thank you. We have noted the direction and suggestion. Thank you, Chair.
Thank you very much. Any other member? Maybe you must take away the slide so that I can be able to see members. Any other member who wants to ask questions or raise any point?
Say, if I may, I still have one point.
Honorable Horn.
Yeah, thank you, Chair. It's just on the discussions we've had last time around, I believe, about section 8.4. And I do believe, whilst we have the discussion, your guidance as the chair was that members must reflect some more on this. I made the proposal that the first subsection or the latter part of the first subsection rather be added to the previous section in order not to create the perception that through an appointment or a dedicated appointment to the land court, a judge appointed in such a way would be entitled to argue that they also in a concurrent way appointed to other sections of the High Court. So I do believe it's something that is still to an extent outstanding. Your guidance was that members must go and reflect on this and express an opinion in the next meeting as to whether they have an objection.
So what is your view? Have you reflected? Honorable Horn?
No, I I made the proposal, Chair, so I'm still very much in favor of it. I think your guidance was that other members must consider the matter and then the committee must resolve on it at this next meeting.
Okay.
That's my recollection in any event.
Yes. Honorable Jela.
Thank you, Chair, and good morning, colleagues, and also Mr. Dupree and the team. Chair, the only question I have, I think you'll realize that I'm a bit quiet on this bill because remember when you started with it, I was on sick leave. But the only one question that maybe clarity question that I would request maybe to ask, it is in relation to the impediments that might, the people who are the claimants might have in relation to the property laws that we have in the country that might maybe impede them in order to do this. When we were dealing with this bill, are those issues maybe considered? I don't know. I'm just asking a question. I don't even know if maybe this question that I'm asking, it makes sense. But I've realized that there are a lot of issues on the property law in terms of that is happening. And you find that these people are coming to claim the land. And you find that there is a contradiction. Maybe the property law says, no, you can't get it because already there are laws that are in existence in terms of the issues of land. Chair, you'll correct me. Just shape it because I don't know even myself.
Okay, no, that's fine. Thank you very much, Mr. Makulubete.
Thank you very much, Chair. I don't know what's happened with me regarding to unmute. I do apologize. Chair, indeed, there are very pieces of legislation that exist in the country that regulate land. And the Chair and the honorable members will recall during the initial briefing by us to this committee, we have indicated that the department has identified about 33 pieces of legislation that are land related. And those pieces of legislation were at that stage, and even now, I must say, they are providing for the court that is going to adjudicate dispute emanating from those pieces of legislation. Now, those legislations that have the High Court or the Magistrate Court will still proceed to deal or to, those courts will still proceed to hear matters emanating from those pieces of legislation. And the Land Court and now the Match Court is going to deal with matters emanating or dispute emanating from pieces of legislation that are listed in the schedule to the bill. Now, in the future, Chair, we have made a provision that the Land Court, jurisdiction of the Land Court can be extended so that certain pieces of legislation can be adjudicated upon under the or in the Land Court itself, thereby removing the jurisdiction of the High Court and dedicating it to the Land Court. Similarly, with regards to the Match Court, if the piece of legislation is decided that a certain piece of legislation will strip away the jurisdiction of the Match Court and then give it to the Land Court, that will be the case. However, the point of the bill is to restrict only those pieces of legislation that are in the schedule to the jurisdiction of the Land Court and the Magistrate Court. Thank you, Chair.
Thank you very much. Honorable Jelle, are you clarified?
I'm fine for now, Chair. I'm fine because remember at those pieces, that briefing I didn't hear, but I'm comfortable with the question that I've asked. Remember,
Okay,
I don't want to take you back. Thank you, Chair.
Okay, thank you very much, Mr. Mokulubete. The issue that was raised by Honorable Horn, that he is in favor of. Mr. Dupré?
Yes, Chair. Okay, can I leave to my colleague, Mr. Dupré, please? Thank you, Chair.
Okay.
Chair, thank you. That is precisely the point that I wanted to raise with the committee. And if I could quickly ask Mr. Makulubete just to share the screen again, please, and then go to the appointment of judges, please. Mac? Mr. Chair, this is the provision that was discussed last week in the committee, and if we can go to subsection 4 of subclause 4, please. Now, this is where the concern was raised, summarized by Mr. Horan, and the paragraph A of subclause 4 is the relevant paragraph, and the proposal was that the last part of that paragraph should be added to subclause 3 in order to clarify that judges be appointed in a dedicated capacity, if I understood the concern correctly, to the court itself, the Land Court. So that is something that I wanted to point out to the committee, is that we wanted to make a proposal there, but I think it fell through the cracks. But yes, this issue is still on the table for consideration by the committee. Thank you, Chair.
Thank you. But I remember us saying that that word, as far as practicable, that we should delete it.
That is correct, Mr. Chair. If the committee decides or instructs the department to include paragraph A towards the end of subclause 3, the wording will change a bit. my concern with regard to the drafting itself at this stage, and sometimes my criminal law professor always said, what's the use of a mind if you can't change it? But I'm concerned about the word must, to use that with as far as is practicable. It doesn't make sense, Chair.
Yes. Yes. I think that is the first, I think that is the second point. I think, but the third point, maybe it's not a third point, maybe I think the second part to Honorable Horn's question, if I understood him, is that if I am appointed through this dedicated court as a judge, and halfway my life, I am bored with land court issues, and I would like to do other issues, won't I claim that I was appointed to be a judge, therefore I'm entitled, I want to go to an ordinary high court, or to deal with issues of competition? What is the practical effect of the clause as it is now? Will that clause be an impediment to me moving from this dedicated court to other courts, or I am just a judge for the land court and not any other court? Did I get you correctly, Honorable Horn?
Yes, Chair, yes. Maybe not to belabor the point, but
Yeah.
when we were initially briefed, I think the idea was put in, and I think soundly so, that land law specialists could in this way be appointed to be judges of this court. So I think the ultimate argument is that for such judges to then move over to other divisions, a further process will have to be followed. We must guard against a phrasing that would enable such judges to say that we are simultaneously appointed as ordinary, as members of the bench of ordinary high courts. Thanks.
Okay. I'm not sure whether my 2 cents of experience at the JSC would assist here. Let's say, for an example, you are appointed to be a judge of the High Court in the Free State. And now you want to go back home to Gauteng. You still have to apply again via the JSC and be interviewed and be recommended to the president for appointment. You can't just write a letter and say, no, I want to jump from this division to the next division. It's via the JSC. You will have to be appointed. There must be a vacancy there. Then you will have to be interviewed and be recommended. I'm not sure whether that would assist. In fact, I'm not sure whether that, if we say they must be appointed as judges of the land court and be specialists there, if a person at any point changes his mind or her mind and wants to do something else, then he will have to be interviewed by the JSC for the position that will be available at that time, whether it is in the High Court or it is elsewhere. That is how the JSC rules are. Mr. Dupree?
Thank you, Mr. Chair. I'm going to ask my colleague to do a difficult thing now, but if at the top of the page where we have the word court, if he could just start, don't go down too much, Mac, don't go down too much. Just show us 3 and 4A, please, so that we see it simultaneously. Thank you. Now, after the word court at the end of subclause 3, insert a comma for us, please. And I apologize for doing this to the committee. It's always, it's not an easy thing to draft in the committee itself, but I think the concerns explained, Mr. Chair, might be addressed by saying, if we read 3 now at this moment, the President acting on advice of the JSC and the Judge President of the Court may, subject to subsection 4, appoint as many judges as is necessary as judges of the court who may have been judges at the time they were appointed to the court. And one could possibly say, who may have been judges of the High Court. I don't know whether this, and then of course, subclause, clause 4A, paragraph 4A will then be deleted, and the rest of it merely renumbered.
Before we proceed, the Honorable Horn.
Yeah,
Does that
thank you, Chair. I think that addresses my concern as well as your concern around must and as far as practicable. Thank you.
Thank you very much. Thank you, Mr. Dupree.
Mr. Chair, just on that point still, the concern that I have with regard to paragraph A at this stage is that it's clearly stated that at least half of the judges appointed to the court must have been judges of the High Court. So just referring back to the proposed amendment then of subclause 3, would the committee still want the principle of at least 50% of individuals being appointed as judges to the court must have been judges of the High Court? I think maybe that's just one issue for purposes of clarity from the department side. Thank you, Chair.
Thank you very much. Members, what is the view?
My apologies, Chair. I don't want to monopolize the discussion, but maybe we must reflect back on reflect somewhat on the initial, let's say, substantiation for this proposal. My recollection is that it was ultimately to enable subject matter experts to be appointed in addition to, let's say, High Court judges. So I think the relevant question is whether this bring into question the idea behind the initial proposal. I do not think it does necessarily, although it of course then brings it more into the authority of the JSC to ultimately reflect on the needs of the court, which is of course also then always expressed by the sitting judge president of the court, who will in such instances form part of the JSC, if I understand it correctly. So in that sense, more of the, let's say, the obligation to look after the court will rest with the JSC rather than for us to then in a strict way prescribe this, which to my mind is not necessarily a bad thing, Chair, but you serve there. You must tell us whether I'm wrong.
But before I do, these people who might not be judges at the time of their appointment, once their appointment, what will be their, would they be remunerated as judges?
Yes, Chair. We do have the provision. I just, for the moment, can't remember which clause it is, but there is a clause dealing with the remuneration of judges to the land court. And if I may, if you will allow me, I tend to agree with Mr. Horan that there is a fail-safe, and the fail-safe is the process in the JSC itself. So the question at this stage might be, does it serve any useful purpose to include that, if I may call it, obligation of at least 50% of persons being appointed to the court must already have been judges of the High Court. So to be short and sweet then, I think it's not necessary, after having heard the response, to include that, but we will be guided by you, Chair. I think the fail-safe mechanism lies then with the JSC and the needs of the court. Thank you, Chair.
I'm not sure, members, but I think if we put it there, it would also assist the JSC in the appointment process, because I do think that if it is not there, won't the JSC revert to its default position of appointing just people who are judges?
Chair, may I come in, please?
Yes, Mr. Makulubet.
My apologies, I don't see the function of raising my hand, but I just want to come back to the issue of the 50% of the judges. Initially, when the bill was processed, the intention was to make sure that when the JSC appoint judges to the High Court, obviously the intention was to have those with expertise in land matters. And now, if let's say the JSC, the intention is to appoint 10 judges, 10 people to be the judges of the court. The intention was to say that maybe then if all of those are from practice, the advocates, the attorneys, and etc., we are not going to have to take everyone from the 10. Others must be taken from the existing judges, so that at least we do not have people who are in the court, who are placed in the court, not having had the experience of being in the bench. So if we have 50% of the judges who are already judges of the various courts, and then from those advocates and the attorneys, then we have 5. I think the intention was along those lines. Hence, the provision as far as practicable, because it may be the case that we don't have many judges who are already sitting judges applying for the post of being judges of the land court. Thank you, Chair.
Thank you, Chair. Thank you, Mr. Makulubete. Then, if that is the case, I do think that both Honorable Horn and Mr. Dupree have a point, because the JSC, when interviewing, it will take this act into consideration as to what are the skills required when whether interviewing a person who is a judge or who is not a judge, it doesn't matter. My initial view, it would be that maybe the 50% is superficial, because the JSC at any rate would they would know that they are appointing a person who would be serving on the land court. So the questions and the expectations, it will be that that person should be quite a fair, if not an expert, on the land matters. I'm not sure whether Mr. Honorable Horn, is that clear now?
Yes, I agree with you, Chair. Thanks.
Mr. Dupree?
Thank you, Mr. Chair. And I'm speaking under correction, but I think during the previous round of interviews by the JSC, I think it was a number of 2 or 3 persons who were interviewed with specific reference then to appointment to the Land Claims Court. So yes, I agree that I think if one applies for an appointment or is nominated for an appointment, the JSC should simply say we consider 5 or 6 candidates for appointment to the land court as permanent judges, if I may call it that. I don't know where I'm technically correct. Thank you, Chair.
Okay. No, any other point on this one? Any other person want to speak? And none. I think this one is taken care of. Mr. Dupree or Mr. Makulubete, you may proceed.
Chair, there's nothing additional from my side. Thank you very much.
Thank you, Mr. Makulubete.
Thank you, Chair. There's nothing from my side either.
Okay. Now, I would like us to conclude this bill tomorrow. And as far as I can read the mood of the meeting, we all agree with everything now, except what the issue of the appeal that must be reflected upon. Can you do it today, Mr. Mukulubet and Mr. Dupree? Can you do it today so that tomorrow we just solve that matter and we move towards adopting the bill? Is that in order, members?
Yes, Chair.
Thank you very
Yes.
much. Thank you very much. So, Mr. Dupree, Mr. Mukulubete, you would just deal with that issue. So it will be the first issue tomorrow, and then thereafter we would move towards adopting the bill. So it would be good that it's adopted tomorrow so that it can reflect on the programming committee of Thursday. Mr. Romano, besides this bill tomorrow, what were we going to have?
Chairperson, initially we're supposed to be dealing with the hate crimes, so we'll only have this item.
Okay, so we can add the minutes. I think the 2 or 3 minutes that are outstanding. I think what we might need to do, because we might have a problem going forward, maybe what we need to do is to committee secretariat just look for a date quite urgently where we will start processing the oversight reports. Because if maybe tomorrow we can start doing, but that will be too soon for you. Just look for a date where we'll start processing the oversight reports in preparations for adoption in the House. Because we made corrections, but we still have to work on the reports, all of them. And then we have a meeting with the 2 ministers. Then the report goes to the House. So I think because we have this challenge with the program, we might need to bring that matter forward quite urgently, because I do think that even on Tuesday next week, after we have done, in fact, we have received the report from Mr. Dupree on the supplementary document. After that, we will still have to give them time to go and synthesize what we would have agreed on into a working document. So that would be, so we would need to give them time. So in between, we might not have anything to do. But I think the drug trafficking would be, yes, we will deal with drug trafficking next week. But I think it will be 2 days or so. So I do think that we would need to process that report in the committee just before we adjourn. So if we can just work on those reports, and members who are assigned to provinces, please make follow-up visits to those provinces. I know that Honorable Horn already he has been to Mpumalanga. We do have a report. We do have his report. He went with Mr. Ramano. We do have his report. We do not have the report of other members. Please, members, let's ensure that these are not seen as just a one-day event or a tour. We have to go back and ensure that what was promised is being done. We have to do follow-ups. The members, they know themselves, those that are deployed to various provinces. And so that when we give a report to the House, that report to the House also encompasses the work, in fact, the follow-up work that we would have done, and to show progress progress or lack of progress thereof. So I think I do want to appeal to members to make those follow-up visits, contact the committee secretariat to facilitate you going back to those provinces so that we are able to finalize this report. Members, are there any other issues? Oh, I think one issue that we have not yet finalized. Members, you received a correspondence that invites you to a workshop on women-related issues. I've only received one apology of Honorable Jele. So I assume that all other members are ready to go to that workshop. Can you please contact the committee secretariat and indicate your availability to that workshop so that we can be able to send names to the speaker as soon as possible? Can we have a deadline of this Friday that all members must indicate their availability so that we can be able to consolidate those names? Any other issue members that would want to raise? Mr. Dupree?
Mr. Chair, I apologize. There was just a break in communication. I didn't hear what your final instructions were with regard to this bill for tomorrow. But what I wanted to indicate to the committee is we have prepared a working document, and we have also in the meantime prepared an A-list, which is actually the A-list must be approved by the committee. So I would like to maybe just receive guidance from the chair whether the committee will approve the working document tomorrow or the A-list. That would mean that it's going to be, we'll have to adapt the A-list according to what we have at this stage. I don't know how the chair would like to approach this, and I'm terribly sorry for doing this to you, Chair.
My understanding is that you would have to work on the A-list to accommodate what was raised on the appeal issues. Then tomorrow we will deal with the A-list we'll have to approve the A-list. because it will be our last meeting. If everything goes according to our plan, it will be our last meeting on this bill.
Thank you, Chair.
Is there anything that you think in terms of procedure and process we are overlooking, Mr. Dupree?
Mr. Chair, I think the committee secretariat and the content advisors would be in a better position to advise you on that. But yes, I think the bottom line is that the A list must be approved. But there will be a slight knock-on effect with regard to the supplementary summary we're working on, but we'll manage it. I'm going to, I'll speak to Mr. Makudubete after the meeting, and then we can just agree how to approach the task with a view to tomorrow. But I would like to apologize in advance that I don't think we will be able to provide you with the A list today. We might have to present it to the committee tomorrow morning if that is in order with you. Thank you, Chair.
Thank you, Chair. Thank you, Mr. Dupree. Committee Secretariat, is there any issue of procedure that we are missing?
Chair, not necessarily, but Mr. Dupree is correct that the committee must adopt the A list. And then there's also some processes that we have to follow in terms of, formatting the bill so that it can be presented to the House in the correct format. And sometimes that takes time because after they've given us the A list, we send it to an outside to format, and thereafter, there are some changes that might need to be made. So yeah, it might take time. So that might also mean that the bill might not be before the House next week if we are not done on time.
No, I think there are two issues we have to deal with. We are not talking about the bill being before the House next week. We are talking about the procedures generally of passing it in the committee, because the decision to schedule it will be the decision of the programming committee. So my understanding is that we would, after we have voted on the A list, then you would go and format the bill accordingly so that it can be ready to be debated in the House. And the House would also have to observe the 3-day rule unless it is through a resolution waived by the House itself. So we are not pressing on the issue of the sitting of the House. I mean, after the committee has approved the A list and approved the bill, then you will have to do the necessary issues of formatting and all of those issues. And then on Thursday, it will be taken to the programming committee, which will decide as to when the bill is debated. It might not even be debated next week. Is that fine, Mr. Raman?
Yes, Chair, that's fine. Yeah. So I think in terms of procedure, that highlighted rule will be the one that should guide us.
The one
make sure that tomorrow the final version of the bill that is to be presented to the National Assembly is before the committee.
Okay. Members, thank you very much, Mr. Ramano. Members, there is an issue that Mr. Dupree has. Before I Honorable Nico Trochen.
Yes, thank you, Chair. I just wanted clarity. Tomorrow we will approve the A list, right? And then after the A list is approved, then we still go through the bill clause by clause, and I just wanted to know that. Thank you, Chair.
Members, I do think that we have done that issue. That is why the outstanding issue that we have now is the issue raised by Honorable Swart on the appeal. So tomorrow we will focus on the appeal, Once the appeal issue is clarified, they are going to be working on it overnight. Then we will go through the A list. And then once we are happy with the A list, then we vote on the bill. If the bill passes, then Mr. Romano takes over in terms of the formatting and all of those issues. They will take it to an external service provider. Then it will be ready to be debated in the House. But on Thursday, then it goes to the programming committee. The programming committee will receive a report that Justice has processed this bill. It's ready to be debated in the House. It will give us a date on when are we going to debate the bill in the House. Is that clear, Honorable Libot Trochen?
Yes, Chairperson, thank you.
Thank you very much. So, the one issue that was, I think it's outstanding from Mr. Dupree that he asked is that he will not be able to circulate the A list today. They are going to work on it overnight. Then we will interact with it tomorrow. But we have been taken through the bill on a number of occasions, and we have made our views on many clauses that we thought needed some penal beating. So can we agree that tomorrow is fine? We will still go through the A list together, and then we vote on the bill. So we do not expect the bill to be circulated tonight to members to go through the bill. Is that in order, members?
Yes,
Yeah,
Chair, in order.
Thank you very much. Mr. Romano?
Yeah, just one issue here, in terms of this rule that I flagged, it says that the committee must formally adopt the final version of the bill as it is to be presented to the House. So I think merely focusing on the A list might not be sufficient. Members might also have to look at the bill as amended, so that they see how the proposed amendments sit in the bill as amended, which would be the B version of the bill and not just the A list.
So which means after tomorrow, after we have gone through the A list, then you will go and do the B list, which will formally vote on it.
Then once we have agreed to the amendments, then they're factored into the bill as originally tabled. Then we create the B, and then members will be able to see the final product, and we adopt that one.
Okay, so tomorrow we'll just ask going through the A list, and then next week we will then vote on the bill.
That would be my proposal, Chair.
Yeah, I know. I don't think we need to. That is how the procedure should be, because if we don't follow it, we run a risk of undermining all the good work that has been done. So I think what we need to do tomorrow, we are voting. In fact, we are dealing with the A list. Then we will deal with the B list next week. Once they have done all the formatting and everything, then we will vote for the bill, which means it will go to the House either late next week or that week before we adjourn. Is that fine, members?
Yes, Chair, it's fine.
Thank you very much. I think that brings us to the end of the meeting, and thank you very much, Mr. Dupree, Mr. Makulubete, and the rest of the drafting team. Thank you very much for the good work done. We hope to see you tomorrow. And thank you very much, members, and to everybody who is watching on the virtual platform. Thank you very much.
Thank you, Chair.
Thank you.
Recording stopped.